Good morning, all. This case management conference is in the matter of CFI 004-2023 and is being held by way of video conference before His Excellency Justice Sir Jeremy Cooke, with a sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Abdullah Al-Awadi, Advocates and Legal Consultants. Lead counsel is Mr. Ibrahim Hanife. The defendants are represented by MB Kemp. Lead counsel is Mr. Salam Matu. Thank you, Your Honor.
Thank you very much. Yes, Mr. Hanife.
Yes, sir. So we have shared the updated CMC sheet by us today.
Yes.
And which includes our response to the questions. And I would love to brief the claim itself on what is it, if you allow.
The basic question, it seems to me, is first of all to sort out the mediation.
Yes, sir.
And there's a question whether or not the mediation is going to take place whilst other matters are stayed or not. And if they're not stayed, then I can give directions. Even if they are stayed, I can give directions which would take effect should the mediation then fail. But as I understand it, the mediation is still alive because the parties haven't got us so far as to agree a mediator. And if you can't agree a mediator, well, I shall point one today.
My Lord, if I can, on mediation, the defendant's position is that mediation and the litigation process should move along together.
I know it is. I know that's what your position is, but let's get the mediation sorted out first, because as I understand it, you're not saying the mediation has failed. You're saying we haven't agreed on the mediator. Is that right?
But basically, so yes, you're right.
Now, hold on. Let me hear from Mr. Matu first. One at a time. It's always difficult.
If you allow me, sir, we have shortlisted 2 mediators,
yes.
And we have shared with the just. Yes, sir. So yet we are on waiting for the directions on who's the mediator will be to proceed. For ourselves, on behalf of the claimant, we are ready to fulfill with the consent order itself. However, I think the only dispute here is between us and the gentlemen on behalf of the defendant, as they have raised an objections where they state that there is a condition into the consent order that the mediation needs to go along with in parallel with litigations, which was our position that it does not include any such condition. That's it.
I understand all of that. But first of all, let me hear from Mr. Matu. Do you have a preference as to the identity of the mediator?
My Lord, we would prefer the mediator that we proposed, and we would like, my Lord, you to make the decision.
Yes.
The 2 outstanding mediators that we have proposed, the 2 mediators we proposed, which one the court favors would be appropriate in this case. That's our position.
Well, I've read their curriculum vitae. It seems to me that since we're talking about parties who are both Czechoslovakian, the obvious choice is Mr. Svatos. He's Dr. Martin Svatos. He's Czech. He will therefore speak exactly the same language as the parties, and therefore he's the appropriate choice. I think also it would be sensible, in order to avoid any further issues, if we can see if there is agreement about whether this will take place in person, and if so, where. I can see otherwise arguments arising in relation to that. Am I right in thinking that at present both parties are... Hold on, Mr. Hanife, let me ask the question. You'll get a chance to give your answer in a moment. But are both parties actually usually resident in Czechoslovakia?
My understanding, my Lord, is that they spend a fair amount of time in Slovakia, which is very close to.
I'm sorry, yes. Forgive me. Yes.
And the mediator can it's a short distance to come to Slovakia, to Bratislava from Prague, and it's more cost efficient as well. So our position would be it will make sense for the mediation to happen there, and all the parties will be present there as well. So it'll make ample sense to pick a date when they will be both in the jurisdiction as such.
And were you anticipating lawyers being present or not?
We at present think that maybe a legal representative will be helpful in the process, my lord. But if they can be present electronically for the purposes of mediation as well, if that facilitates the process, there could be many permutation and combinations in that. But primarily to save costs, it will make sense for the mediation to happen in that region as such, and all the documents being potentially a lot of documents being in the Czech or Slovakian language also will assist in that process.
Yes, Mr. Hanafi, what do you say about that?
So first of all, my client, the claimant, spends most of the time in the year in Dubai, and she's now in Dubai. She's not there, and we do prefer counsels to also be a part of this mediation sessions.
Yes.
Either the online, we have proposed to the defendant that it might be better to go for online sessions rather than physical meetings, unless the mediator, we will leave a room to the mediator to decide whether it's going to be more practical if it's in person rather than online. So I do suggest that having the dispute, even it's in Dubai itself, and the court is in Dubai, the claimant is in Dubai. One-party counsel is also in Dubai. English is a language where all parties can speak. For the documents, if any of them is not in English, we can get it translated. So we do suggest that the mediation to be in Dubai, leave a room to the mediator to decide whether it is going to be in person or online, and not to be in Slovakia. Because if it is in Slovakia, I believe if the mediator decided for an impersonal sessions, will not be able to join, will not be able to be a part of this, and it will not be a cost efficient for both parties then.
My lord, if it helps, we don't.
I was going to ask. Let me ask. I assume both of you have had experience of mediation. My own experience is that it's much better if it is in person.
I would agree with that, my lord.
With the mediator who travels from one room to another and talks to the parties. And it's usually helpful, in my experience, if there is a lawyer there, because lawyers are intended to calm things down and bring an objective rationality to the process that sometimes the parties aren't capable of because they are so emotionally involved in it all. So I think the answer is that I should leave it to the mediator because he will know how best he wants to conduct it. But I would favour, in order to give it the best chance of success, and after all, it's going to be a commercial deal at the end of the day. It's not going to be one that turns necessarily on the legalities of what either party has done, whether rightly or wrongly. There's a basic conflict, and there'll have to be a commercial deal of some kind, and it's a sort of case which makes obvious sense for a commercial deal to be done. So what I shall do is that I shall appoint Dr. Martin Spartos. I hope I've pronounced his name correctly.
That's correct, my lord.
And leave him to determine exactly how it should take place. But my recommendation would be that it takes place in person, in one jurisdiction or the other, and that a lawyer is present for each of the two parties, and leave it to the mediator to resolve. Does anybody have any problems with that?
No, my lord, not from the defendant's end.
Mr. Hanafi?
Not from my end with respect to to name the mediator, but with respect to the jurisdiction on where the mediation will take place.
And why do you think it's so much better that it should happen in Dubai rather than in Slovakia or even Czechoslovakia? Come to that.
The case being started and initiated by the claimant she's now living in Dubai. We are her counsels. We are also in Dubai.
Yes.
While if it's going to be taking place in Slovakia, then both parties and the claimant needs to fly to Slovakia, then in which is going to be incurring more expenses. and
All
costs.
Right.
So
Right.
I
Well,
do. Yes, sir.
I'll leave that.
And
I'll leave that to.
Okay, sir.
Oh,
And I believe Mr. Okay, sir.
No,
Mr.
you
Salah,
My lord, my lord, if
finish.
it helps.
Mr. Salah used to visit Dubai oftenly, so I don't think that it's going to be an issue for him to come over to Dubai to be a part of this mediation.
My lord, if it
But
helps.
I don't think
our office and the parties, all of them are welcome to conduct the decisions in our office as well.
I understand. Well, I'm going to leave this to Dr. Svartos to decide. It's for him to decide what is going to be the most convenient, efficient, and cost-effective way of mediating. He's apparently an experienced mediator, and he may have to mediate on the question as to where it's going to be. But there we are.
My lord, I just want to make one short point on this, and that is, if the decision of the mediator is it will be in Dubai, we will not object to it, and we will happily come to Dubai, and it will not be an issue at all.
No, well, let's leave it to him to decide. You can each tell him what you think is the best thing to do, and he can decide for himself what is the best thing. Now, it seems to me that looking at the terms of the order that was made last time, although it wasn't expressly said that there would be a stay in proceedings, it does say in paragraph 1E that if the case is not finally settled, the parties shall inform the court prior to the case being relisted. And so the clear implication was that there would be a stay. Whether or not that was clear, it doesn't make sense for the parties to go on spending money in the litigation whilst they're mediating. And so, subject to any submissions the parties want to make, what I would propose to do is to give an express stay for a short period during which the mediation can take place, but at the same time make directions for what will happen in the event that the mediation fails. Now, does either party want to address me on that? I mean, 3 months would be the sort of period during which a mediation should be successful.
For me, it's fine, my lord.
My lord, our preference would have been to have processes travel along this litigation process to more along. But we understand what you've suggested, my lord, seems reasonable, and the parties will not incur costs, and I think 3 months should be fine. I think, my lord, especially given
more than adequate, yes. I would think, but it may depend
yes.
on Dr. Svartos' own commitments. He has other things to do. But if I say a stay for 3 months or the conclusion of the mediation, whichever is
earlier.
Whichever is earlier, yes, and because if it hasn't happened in 3 months, I shall want to know why. It suggests that something's gone wrong. So stay for 3 months or conclusion of the mediation, whichever is the earlier. I'll leave it again to the mediator to decide what he wants by way of mediation statements from each party and so on. He will know how he likes best to conduct these matters. All right, so that then gets us back to the question of directions, which would take effect after 3 months, effectively. Now you've both now filed or either filed additional case management sheets or submitted skeletons, which I've read. Let me just say this. It seems to me that there's not a hope of this case being heard in 3 days. Just stop and think about it for a moment. If we've got 4 witnesses of fact, if we've got 2 experts, one of whom will be dealing, one on each side, on the question of the share valuation, and at present it seems to me there is room for an expert on tax optimization, but I'll come back to the most sensible way of dealing with that to make sure that there is a relevant expertise. But just assume for the moment we're talking about 4 witnesses and 4 experts, 2 on each side. I normally reckon we're talking about half a day for each witness, usually, something of that kind. 1 or 2 may go shorter, some may go longer, but the main protagonists will plainly be in the witness box quite a long time. It seems to me that we're talking probably about a 7-day case. What do you say about that, Mr. Hanifi?
So first of all, thank you very much for this suggestion. However, I would like to add here that the expert requirement from our end on what has been already stated into the sheet which we have uploaded yesterday is with regard to the necessity on the tax optimization. Number one, whereby some other reasons that we have not mentioned, and we have concentrated on the most or the core of the claim itself. So we have also the part which is related to the claim made by the defendant of paying the joining fees into the DIC company. Yes. Number one. Number two, the services rendered against the invoices being issued on behalf of the DIC company and on behalf of Pollux, which is used to be a company belong to the defendant. We need also to clarify the elements and the facts mentioned into the assignment agreement for receivables on the claim of the debts of the defendant against the Pollux of 800,000 or 900,000, 75,000 euro, and the other matters related, all in order to prove the fiduciary relationship and to prove the breach of this fiduciary relationship, and to prove that invalidations of the receivables agreement assignment receivables agreement and the joint venture agreement itself, and the establishment of the DIC company itself, in which will lead to defend indirectly the counterclaim being made against the son of the claimant with regard to transfer of the shares from the DIC company to her son. So these are actually, yes, these are actually the grounds which might not be mentioned in details into the CMC sheet, in which we are asking an expert to be appointed. So from our end, we have suggested 3 names in which we will be deciding one after the permission of the court. And yes, we do agree that half a day is going to be enough for an expert to be examined.
Yeah, but I understand all of that. Most of the points that you've made, which are plain on the face of the pleadings, they will either be determined by the documents or by the fact evidence. The expert evidence will be needed in relation to the nature of the advice that was provided by the defendant. And I can see that insofar as it's said to be legal advice and tax optimization advice and so on and so forth, and whether any of it makes sense in the context of what is said to be a big fraud. I can understand all of that. But my first question is, how long is this trial really going to take? If you reckon that we're talking about 8 witnesses of one kind or another,
we have proposed 3 witnesses, I believe,
yes,
and then 1 expert. So yes. I think
well, it'll be 2 experts, won't it, Mr. Hanifi? Because you'll need someone, unless the same expert does the share valuation as well.
So we anticipated
the valuation of the shares.
We anticipated
is plainly an expert matter.
Yes, we anticipated maximum 3 days for the trial.
Yeah, I know you did. I can't see how that can possibly be right.
Yes, then we're fine for 5 days.
Well, let's just explore it. I'll ask Mr. Matu in a minute. But on the face of it, if we've got 4 witnesses of fact, 3 on your side and 1 on the defendant's side, say half a day each, that's a minimum of 2 days, and possibly slightly more. Then we've got, let's assume, a minimum of 2 experts, but it could be 4, and that's what I'm trying to explore with you. But if it's 4 experts, that's another 2 days. And then you've got openings and closings. So it's bound to be 6 days. It's going to go over the week. It's the real problem, it seems to me. I don't think we fit it in the 5 days, but I might be prepared to try. But it really does depend whether you're going to have the same expert who deals with tax optimization and the nature of the services and the share valuation or not. Obviously, it's all forensic, well, mostly forensic accountancy. But will it be the same expert?
No, KPMG and Talal Abu Ghazala are into all of these fields, including the tax forensic and even evaluation plus
yes, I understand that. But would it be the same person at KPMG, or will they need two different people who specialize?
Actually, they have their own internal departments, I do believe. So it wouldn't be the same person for all of the parts of the mandate itself.
That's what I meant. So it's likely you're going to finish up with two people on your side and two people on Mr. Matou's side. Mr. Matou, what do you think about the length of time?
I think, my lord, we agree that your lordship is right. It will at least be 6 days on the basis there will be 2 extra set of experts. But on the issue of tax optimization, my lord, it's essentially a factual question whether our first defendant provided tax optimization advice or not. It's not necessarily an issue of what advice was provided. The main issue is that they provided allegedly an advice that had fiduciary obligation implications. And
well, it goes further than that, doesn't it, Mr. Matou? Because what's actually being said is that the advice which was given was to render fictitious invoices in order to achieve a tax object. Now, I mean, if that is right, if that's what's going on, then on the face of it, it would be unlawful tax advice, or at least that's the argument. And so an expert will need to give an opinion as to whether or not any of this makes any sense.
We agree on that, my lord. It is a correct direction that we would need an expert to determine that point, and an expert would be some kind of a tax lawyer, I would say, on that front, who would be more appropriate to look at all this.
Well, it would be either a tax lawyer or a tax accountant.
Forensic tax accountant, yes.
Yeah,
but
one of the two.
From our perspective, my lord, it will be a quantum expert might not necessarily be a tax expert.
No, it could just, as you say, I think it almost inevitable that you'll finish up with 2 accountants or 2 experts on each side. That means 4 all told, plus the 4 witnesses. I think we're looking at 7 days realistically. Let's work on that assumption for the moment.
My lord, with respect to the speciality of the experts, I believe we have suggested one of the big 4.
I understand that, but you, the way it works, as you probably understand, Mr. Hanife, in the DIFC, we don't have a court-appointed expert.
Yes, sir.
Each party appoints its own expert, and it'd be simply a matter for you to decide who you want to appoint. If you go to KPMG or one of the other big firms, and they can advise you, well, we have Mr. So-and-so and Miss So-and-so who can do one bit and the other bit do the other, but you'll need to talk to them about it, and likewise Mr. Matou. But on the face of it, I think we should be planning for a 7-day trial with these number of experts, all of which, of course, makes it much more sense for you to mediate than run the expense of a 7-day trial with expensive accountants. You'll spend a lot of money on accountants.
We agree, my lord.
I do agree.
A lot of money on accountants, a lot of money on lawyers. But the point at issue is this, that once we say we've got a 7-day trial, and this is a case management conference, which is why it's a form of discussion between the 3 of us. Once we say we're into a 7-day trial, the question is when that's going to be, if everything then is held up for another 3 months while you mediate. So we need to be setting a timetable.
I believe we can shift all of the proposed dates in our sheet for another 3 months then.
Well, the question is, when are we going to have a trial? That's the key question.
We have proposed September, my lord, so we can then we can then move it to December.
Well, that's all very well, Mr. Hanife, but it depends if everybody's available.
Okay, sir.
In particular, whether I'm available, because as you may or may not know, I sit as an international arbitrator, and I have dates running to the end of 2026 at present. So we've got to find a 7-day period that works for me, unless you want to go have a different judge, which of course is perfectly possible. But I can tell you what I can offer.
Then December might not be a preferable option. Then we can go for January. Having December is going to be a lot of holidays involved.
My lord, I was going to suggest, when is your lordship available for 7 days?
I was just going to have a look and let you know, to give you the earliest possible date, and then you can decide if you think that's too far ahead. You could decide, ask the court to have another judge instead of me. It's doesn't matter to me in one sense whether I do it or whether another judge does it, but because I'm familiar with it, it makes sense that I should do it if I can. Now, let me just tell you where we are.
My lord, our preference would be to keep you as the presiding judge, because I think you've had a 2-year period with the case, and it will make sense for you to continue on as a judge to the trial.
7 days. I could do 7 days. It would probably actually have to start on Tuesday, the 16th of December. That would be possible, or I could do the 5th of January.
Both are fine for me.
And my lord, we came prepared today for any eventualities, and our senior counsel and our quantum expert also that we have identified, they will be available to do both sets of these dates.
Right. And what about the 12th of January?
12th of January is also good, my lord.
Right.
For defendants, my mother's friend maybe confirm his availability.
I'm also okay.
Yes, you're okay on any of those dates. Well, let's just see now which of those really makes. Well, what have we got to get in first is the question. Let's look at the bear with me a moment. Yes, disclosure. Now, I'm working therefore on the basis we're going to have a trial sometime in the December-January period, and then let's look at the timetable to see if that works, on the basis that we're now having a stay for what is effectively, where are we now? Nearly the end of March, April, May, June. So we're talking about things beginning in July, aren't we, really?
Yes, my lord.
Which gives you 5-6 months. That should be all right.
That should be perfectly adequate time, my lord.
I think so. But when you talk about standard disclosure, what I'm talking about is standard disclosure in the English sense of the word. I think this is a case which requires both parties to give disclosure of documents that both they rely on and documents which undermine their case or advance the other side's case. I suspect that they will still give rise to requests for documents thereafter, but it would be a form of disclosure in accordance with let's find the relevant rule. Yeah. So if you look at, you don't need to look at it now, but RDC 28.15.3 gives the court power to order disclosure on what is a standard basis in English law terms, which is in accordance with the CPR 31.6. But what it means is that each party is under a duty to disclose those documents which both advance its own case it wants to rely on, and those which undermine it or advance the case of the other side. And that's based on the pleadings. Now, for that purpose, it seems to me that it would make sense for leading counsel on each side to produce a list of issues. And the sooner that can be done, the better. That would actually help you possibly in the context of the mediation too, actually, to have a list of issues so that you can focus a bit on the merits in coming to a commercial deal. But it would be that form of disclosure, which is obviously more arduous and takes longer than the ordinary form that's adopted in the DIFC of request to produce. But if I were to say that standard disclosure was to take place by sometime in July, then we would move on to witness statements some 2 months later, something like that, and expert evidence a month after that. So we'd then be looking at July, September, October,
Yes.
With supplementary witness statements and supplementary expert evidence to fit in. And that all ought to be doable by a date for trial in December or January. Does that make sense?
Yes, my lord. Yes.
Yes, sir.
All right. Well, let's just try and organise that then. Let me just decide which is the best date, allowing 7 days. I think bear with me a moment. Actually, I don't need to decide that this very moment, as long as we set up the timetable, and we can confirm dates subsequently. But let me just look and see if I can force it out now.
My lord, essentially, the parties are in agreement. It will be a date in December and January that you have indicated, and your lordship can take further time to see what will be most appropriate for yourself, and then we can pencil that in at a later date if you need more time, your lordship.
Well, I think that would be sensible, but I'm just trying to have a quick look now to see. It looks like, I think January the 5th is going to be the best date. So
that's perfectly fine for the defendants and for my learned friend as well, as he's indicated. We have one further preference. We would prefer the hearing to be in person.
Yes, well, that's what I was envisaging. It's going to be a conflict of evidence, and if I'm going to try the matter, I prefer on any trial that lasts more than 2 or 3 days for it to be in person. And if I got to form a view about credibility of witnesses, it'll be in person in the DIFC. So we'll need to check with the court that the court can do that, but I've no reason to believe they can't. So we're going to say 7 days starting January the 5th. Now, going then to disclosure, it's the easiest thing to use one of you's produced a draft order. Is it your draft order, Mr. Hanife or Mr. Matu?
We have just received the one which is amended by yesterday, so yet we have not gone through.
No, well, let's have a look at that and see if we can get dates that work in that. So
we
we're
have
going to
submitted, my lord, a draft order yesterday. I'm not sure if your lordship has received a copy
yes,
of it.
that's the one with red line or blue line
Yes, my
alterations.
lord.
Talking
right.
about disclosure on the 28th of April.
That's right, my lord. Yes.
Yeah, all right. Well, we'd start off with a provision for stay. This
Yes.
action shall be stayed for the purposes of mediation. With Dr. Savatos as mediator for a period of 3 months or until conclusion of the mediation, whichever is the earlier. So that's item 1. Item 2, the parties shall proceed to mediation in accordance with the directions of Dr. Svatos. Then 3, they move on to disclosure, and the parties shall disclose documents on which they rely and which advance the case of the other party or undermine their own case by, let's say, mid-July. Does that make sense?
Yes,
Sometime
my
in
lord.
middle of July?
14th of July. 14th of July, my lord. Monday, 14th of July.
Well, yeah, it's 14 July, as good as any day, Mr. Hanife.
Yes.
14 July, thank you. Then inspection, by which I mean provision of copy documents. Uh, 2 weeks later, 28 July.
I believe depends on the documents disclosed. So I believe it depends on the amount of the documents disclosed. So is it 2 weeks? Is 2 weeks are enough? I don't think. I believe 3 weeks is going to be more better than 2 weeks.
Well, we're just talking about inspection, about production of the documents that have been listed by way of disclosure. I mean, maybe that you will actually disclose the documents themselves. How would you plan to do this, Mr. Matu?
I would have thought, my lord, by the time by 14th of July, both parties would have reviewed all the documentation that they want to rely on, or that undermines their case. And on the 14th of July itself, we could be disclosing the documents electronically or by other means to each other.
What we're going to need, though, is for the parties to liaise before that in relation to electronic documents and word searches and all that sort of stuff.
Yes,
so that
we could
realistically, you need to be discussing that beforehand and going through the. I mean, if you look at CPR 31.6 and so on, you'll see. I'm sure you're familiar with this, but perhaps the more I think about it, that's a little bit too quick. You should be exchanging pre-disclosure electronic document questionnaires on the 14th of July, and then making disclosure at the end of July.
I think that's sensible, my lord. I think we agree with that.
All right, so it's electronic disclosure questionnaires
Yes.
by 14 July and disclosure 28th July. And then there's bound to be some sort of argument about the adequacy of that.
Yes.
So we'll leave a gap for that to take. Well, no, actually, we'll say further requests for documents. Now, so far as you're concerned, is August a holiday or is August not a holiday?
My lord, maybe a holiday for a week, but not more than a week for us, my lord.
So it's not going to affect you particularly, is what you're saying, as long as we are given sufficient latitude.
Yes, my lord.
Mr. Hanife?
It's fine for us. So
Right. As you probably know, Mr. Hanife, English judges always take nearly all of August off. It's one long holiday.
Even in Dubai, all people are taking off during August and July. But for
Yeah, well,
myself, I'm fine to stay in Dubai.
Right. Well, they leave Dubai, don't they? Because it's too hot.
Yeah, it's too hot. Yes, they're
right.
in London. They are in London.
yes. Well, there we go. All right. So we'll say further requests for documents on, let's say, the 18th of August. Responses
by way of an application, my lord. It
no. It's to the other party. So it'll be like a Stern schedule or a Redfern schedule or something similar.
Yes.
I prefer a Stern schedule because of the layout's easier, but it doesn't matter.
That's fine for us, my lord. Stern schedule works for us.
Stern schedule 18th and responses by the end of August, which will be let's say the 1st of September.
Yes.
And yes, it'll just about work. And further claimants or reply from the party replies on the 8th of September.
Yeah.
And the court will then decide any court decision well, I'll give myself 2 weeks, 22nd of September. Witness statements. October.
That works, my lord, yes.
Is there any reason why the experts shouldn't also produce their reports at the same time, or will what they have to say really be dependent upon what the witnesses say? Shouldn't be very dependent, should it?
No, we agree, my lord.
Could be a week later just to make so they can add in anything that they need as a result of the witness statements. Experts, 20th October. Supplementary witness statements, short supplementary witness statements, which should only respond to new points.
27th September.
Too soon, I think.
No. Yes.
3rd of November.
3rd of November, sorry, yes.
3 November, and supplementary experts reports.
A week later.
Yeah, 10th November.
Yeah.
That then gives effectively a bit of latitude until a trial at the beginning of January. So you've got 2 months then in case things go wrong and everything gets pushed back as it usually does. And skeleton arguments 1 week before. Of course, that won't please you very much, will it? On the 5th, that'll come at the end of December. There will be people taking time off in December, I suspect.
Yes, my lord. I think that will be slightly problematic.
Well, let's say, well, the bundle of documents is for the trial is the other thing. When could you do bundle of documents for trial, given the fact that we're into the December period?
My learned friend, being the claimant, might have the first stab at this, so maybe he can indicate what would be good for him.
Yeah.
So I'm okay with the suggestion of the court.
I'm sorry, I didn't get that, Mr. Hanifa.
Saying that I'm fine with the suggestion of the court. That I think it's going to be before the trial, like 2 weeks.
Yes.
It might be helpful to have trial bundles sometime in early, by end of November, my lord, because
I believe
you'll never manage that.
or early December, for that matter.
Yes,
because
well, that's more like it.
Yes, December, because the trail is
December the 15th.
Yes, it's fine.
That's more. Yes,
December the 15th for the bundle of documents, and then agreed bundle by 15th December, and then if we're starting, what did I just say? We're starting on the 5th. If I said skeleton arguments on the 2nd,
Sir, my lord, we are starting at the 5th order. We're starting at 12th, I believe.
We're starting on the 5th, I think is my best date, really.
I believe you have mentioned 12th somewhere.
Yes, that was a possible as well, but I think the 5th is going to be a better date. Presumably there'll be New Year celebrations and holidays and what have you.
So my
lord, 2nd should be fine for skeletons. We are grateful from our perspective, so I think that should be fine. Christmas, it gives us some time to recover after Christmas, and that should be fine.
Well, it all depends on what you're doing on the New Year. But Mr. Hanifa, is the 2nd of January workable?
No, sir.
I thought you might say that.
Yeah, because first is going to be a holiday in Dubai for the fireworks as usual. So
yeah,
and
well,
Dubai
that's what I thought.
Yeah.
Well, I tell you what, if we start on the 6th of January, on the Tuesday, we could say skeletons on the 5th.
My lord, 2nd is corresponding Friday, Saturday and Sunday, then 3rd and 4th, which are a weekend. So 5th again, it's not going to be possible. So I believe.
My lord, if I can suggest something.
Yes, go on.
Maybe the parties can submit the skeleton on the 31st of December.
Well, I think that would be easiest from everybody's point of view.
Yes, and then we can have a New Year break and then prepare over the weekend before the trial. I think that would be the best possible outcome here.
Well, and if we start on the 6th, we'll give you the Monday as well.
That's right, my lord.
So that make the trial date the 6th. And it is early to be doing skeletons 2 weeks in advance, but actually, because of holidays, it's probably the easiest thing.
That's right.
So what date do you want to say? The Friday the 19th, or the Sunday the 21st, or 22nd, or Monday the 22nd? Monday the 22nd is
Monday the 22nd is fine. Yeah.
And we'll make the trial starting on the 6th of January, so that then parties have got at least a little time prior to the trial to get
So
into the
skeleton
case
is going
again.
to be 22nd of December.
22nd December, please, Mr. Hanifi.
Yeah.
Yes. Right now, does that cover the ground? Wait, we've got to deal with the question of experts too, in terms of the fields of expertise. So you've provided for valuation of shares. Yes. In respect of the valuation of shares and the tax optimization advice given by the defendant, brackets if any. leaves the point open for discussion then.
So allow me, we are on the assumptions that the other factors we have mentioned at the beginning of the CMC is also is covered under the tax optimization definition. Means we do also consider the expert for the other things that we have just discussed at the beginning of this meeting. So it's not going to be only for the tax optimization part.
Well, that's mostly fact evidence, isn't it, Mr. Hanifi, as to whether or not any services were rendered?
Yes, sir. But I mean, when it's going to be also mentioned in the expert report in a more technical accounting perspective, it might strengthen and substantiate the fact.
Well, just tell me what the expert would be likely to say.
Actually, based on the claim of the defendant that these invoices are due for services whereby there are no services, then the expert has to look after whether there are services being provided, yes or not, in which support our claim that the tax optimization was an advice made by the defendant.
Well,
and there is also one part which is related to the payment of the joining fee, which is also a fundamental point here. It has to be also clarified, sir.
Well, but aren't those really questions of fact as to whether any services were rendered and what payment was made, or should have been made, or will turn on the documents? I mean, I'm not going to stop the expert saying dealing with matters that are truly expertise, but he can look at the accounts to see what money has been received and what money hasn't. But in terms of services rendered, that ought to be simply a question of fact. What troubles me slightly, Mr. Hanifi, is this: that if your expert goes into all sorts of areas that aren't truly expertise, then we're going to get into an argument about it afterwards. And the only possibility that occurs to me would be to have a sequential exchange, experts' reports, so that there isn't any room for difficulty about one expert not dealing with what the other expert's dealing with. Do you understand what I'm saying?
Yeah, so that's why I'm just trying to make it clear on what are the mandate of the expert, or what we are anticipate the mandate is about. So the mandate is, the mandate of the experts, the way that we are expecting, is that first of all, the tax optimization issue.
Yes.
Number two, whether if service has been rendered against the invoices issued, regardless payments made or not, whether these invoices that the defendant is claiming are against an actual services being provided, yes or not, because this would prove from our point of view that it was all a fake tax optimizations proposal. So this is the second part. The third part is, if you allow me.
Go on, yes.
The joining fee, the way that being decorated by the defendant under the agreement of assignment receivables has to also be checked, determined, and made sure that everything is mentioned there was correct and a fact, but not to manipulate the whole situation. So
Yes. Is there anything?
No.
Anything else? Anything else that you want the expert to deal with?
So actually, these are the most important and fundamental points. We are on the opinion that are required to be looked after by an expert.
Right. I'll tell you what I'm going to do. I'm going to change the direction for exchange of reports so as to make sure that there is no question of the experts dealing with different things. And I'm going to require the claimant's experts to go first, followed by the defendant's experts. And then if there's any argument about whether something is admissible or not, we can deal with that later. But at least there'll be no question of the defendants not knowing what expert evidence is going to be adduced. Do you follow, Mr. Matu?
Yes, my lord. We agree with that. And given
that seems a sensible approach to make sure we don't have ships passing in the night.
I just wanted to make a short point, my lord, on some of the issues my learned friend raised. Yeah. A number of these issues are factual points that you.
Well, they cross over, don't they?
Yeah, which you will have to determine, my lord, rather than an expert. So
I agree with that, Mr. Matu, but nonetheless, there is accountancy evidence that relates to it self-evidently, so that the experts, the accountants, to deal with what sums changed hands and what invoices were submitted is obviously important, as well as looking at the fact side. Was anything actually done to justify those invoices? So there's going to be a crossover, which is why I'm prepared to let the experts deal with it. And likewise, the joined-in fee and the scheme for the assignment of receivables and so on. There are plainly forensic accountancy expert issues there, as well as factual issues as to what actually happened. So to make sure no one's taken by surprise, the claimant's expert can deal with that, and then we'll have your expert, and I'll adjust the timetable in a minute to take account of that. All right. I think that's just about got it, subject to working through the timetable again to make sure we're all in agreement, and pre-trial review and so on. Right, let's go through all of that from the start and get the dates right. So who's going to draw up this order? Are you going to draw it up, Mr. Hanife, and then submit it to Mr. Matu for agreement, or do you want me to make the first draft and send it to you for your to make sure I haven't left anything out, and then it can be approved by the court? Which is the easiest?
We do prefer, sir, yourself to do it and share it with us.
Right. Well, I think that would be quickest, don't you, Mr. Matu, rather than leading to arguments?
We are fine with that, my lord. We're very grateful for your help with this.
Yes, sir.
I will produce a draft after we finish today, which you'll get sometime during the course of the day, for your comments, to make sure that there's nothing that I've left out or misunderstood. And I'm not asking for any further argument about it. It's just to make sure I haven't left anything out. And then you can send it back to the court with your comments. But what it's going to do is this then. First of all, the stay for 3 months or conclusion of the mediation. Secondly, the parties proceeding to mediation in accordance with the directions of Dr. Sartos. Thirdly, electronic, there'll be disclosure in accordance with the provisions of CPR 31. Electronic disclosure to take place by the 14th of July.
Yeah.
Disclosure the 28th of July. Request for further documents 18th of August in a stern schedule. Response by 1st September, reply by 8th September, court decision by 22nd September. Witness statements 13th of October. And what I'm going to say, Mr. Hanife, is the claimants will produce their expert report on the same day, on the 13th of October. Yes, 13th of October. Then there will be defendants' experts' statements, and I'll set out in the order to what the experts' evidence is going to relate in accordance with our discussion. Defendants' experts will have to be a month or so later, won't they, on this basis?
Yes, my lord.
A lot can be prepared in advance, but
I think 4 weeks will suffice, my lord. I think 3 weeks should be 3 to 4 weeks.
Yes.
Because we would expect our expert to have done a lot of work already, given your directions.
Exactly. So let's say the 3rd of November. That gives 3 weeks. Then supplementary witness statements on the 10th of November.
10th of November, yeah.
And we're then into
So we have one point which we have mentioned into the sheet. That's we will be having an amendment to the claim.
Ah, yes. Now, what sort of amendments do you have in mind?
It's not going to be in the relief sort itself, but it will be related to the facts and producing new documents related to the fiduciary relationship.
Yeah, but what's the amendment? What's the substance of the amendment that you want to make?
It's if you can see the claim in the particular of the claim, the fiduciary relationship has been strengthened by way of attorney to a client basis, in which we want to further submit new facts to prove that it was not only due to this ground a fiduciary relationship, but to also other agreements and emails, correspondences that not have been that didn't be submitted to the court before.
Right. Well, when are you going to produce? When do you going
We'll
to be in a
find to
position
do it within we'd find to do it within 2 weeks from today.
All right, regardless of the fact that mediation is coming up. All right. Well, let's say then any draft amendment to particulars of claim to be served within 2 weeks. And at that point, either Mr. Matu will consent to the amendment, or he won't. But the stay will come into operation, and we can come back and argue about all that at a later stage if need be. So I don't think I need make any further order other than that, because if there's consent, then there's no problem. If there's not consent, then you'll have to apply for permission to amend after the mediation has failed in these circumstances, and then we'll have an argument about it. All right. The other thing I did mention was list of issues, and I should have thought that the right thing to do is for the list of issues to be produced at the same time as the electronic disclosure questionnaires, because that will inform the whole business of disclosure. So I'll provide for that as well. Seek to agree list of issues, or failing agreement, each party to produce its own list. Okay. Now we've got as far as supplementary witness statements on the 10th of November. and then it'll be supplementary joint meeting of experts will be
on the issues they disagree with, my lord, right?
Yeah, well, what I was going to suggest was they have a meeting and then produce a short memorandum.
Yeah.
Of what they agree and disagree. So, joint meeting of experts, that's 10th of November was the supplementary witness statement. So, 3rd November, better be the 24th of November, by the 24th of November, and joint memo of agreement and disagreement by the 1st of December.
Yeah.
It's running quite tight now, but there we are.
Yeah.
Do we need to have a reply reports? Will that be helpful or not in these circumstances? I suppose we better have them.
I think it would be required. It would be required.
Maybe a week later. Reply reports on the strictly on the issues of disagreement.
Yeah.
When we're saying a week, when we're saying a week, then it's a 5 working days. So I would like to mention it's 7 working days rather than a week.
Well, they will have met on the 24th of November. They'll have produced a joint memorandum of what they agree and disagree about on the 1st of December. So they'll be in a good position to have done their replies a week later.
Yes.
You know, they will have been through it all together. So 8th of December ought to be all right. And that still does.
I can't decide on their behalf from now. So
yeah. Nor can we. But it seems to me that if they've had the chance to meet and say what they agree and disagree about, the memorandum will simply say that, and that's a week later. They've got 3 weeks then, haven't they, or 2 weeks? Let's work on that basis. There's a little bit of give and take there. Parties aren't going to be silly about it. But since we're producing a bundle of documents a week later and skeleton arguments a week beyond that and the trial on the 6th of January, it's all got to be quite closely tied together. I'll produce this draft and you can have a look at it. If you say, well, actually, that's just not possible, then you can talk to each other and see if you can agree to fiddle around with it a bit.
So,
anything else? Anything else at this stage?
Yes, we just want to make sure who's going to be the party, who's going to share the directions with respect to the mediation to start. Is it we or the defendants?
Well, because you're the claimant,
sure.
You would. It's up to you to approach Dr. Svartos and to make arrangements with him. Telling him what the court has directed and give him a copy of the directions, and he can then sort out with you quite how it's all going to work. He will approach the parties and deal directly with you.
Sure, sir.
Now, does that just about cover the ground, or is there anything else that I need to deal with now?
Nothing further from our end, my lord.
Me too,
Mr.
sir.
Hanife, all good?
All good, thank you very much.
Very good. All right. You should get something later today, though I'm several hours behind you. It's only 9 o'clock in the morning here. But if I get this draft done by, say, 10 o'clock, the court might get it to you during the course of the day in Dubai, just about. If not, you'll get it tomorrow, I guess. Unless you want to give me your email addresses and I can send it direct to you. I don't mind doing that.
My lord, we don't object. We are in London anyway, so we should be fine.
Right. Can you give me your email addresses and I'll send it direct to you? The court,
yes.
Court doesn't usually like this because they don't like me giving you my email address. So once you've got my email address, you'll have to swallow it or get rid of it somehow.
I will be writing my email into the.
My lord, I've just inserted my email in the chat function in our Teams.
Brilliant.
We'll see. Yeah.
Brilliant. And can you do the same, Mr. Hanife?
Done already, sir.
Brilliant. All right. Thank you very much, both of you. If you'd each like to sign out, and if everybody would like to sign out, except for Haley and Ayesha and any other members of the court staff.
Thank you, my lord, again. Thank you.
Thank you
sir.
very much.
Thank you very much.